So I want to take a minute. My name's Colleen Clark, and I'm the CEO of the Greater Langley Chamber, and I want to thank everybody for joining us today. I especially want to welcome our guest speakers, Sarah Forte and Jim Wu from Forte Law, Employment Law Solutions. I just want to give a quick chamber update before we get started. This morning were several announcements regarding School District 35 and all the schools, plus the announcements from WorkSafe and the sort of guidelines and information you're going to need regarding reopening has all been released. The link on WorkSafe BC, as you can imagine, is crashing quite often. Where we were able to get the link, we were able to start getting it out there, but it keeps crashing because so many people are trying to log on. So be patient with them. The information is up there, and we'll have more of it on our website as soon as we can get the link to stay up for long enough. And so moving into that, I do want to take a few minutes to introduce our guest speakers. Sarah is returning to her roots here today, moving into Langley. She grew up in Langley and attended Brookswood Secondary School, not far from where I'm sitting today. She's been an employment lawyer since 2004. Prior to law school, she was an HR professional. She founded Forte Law in 2016 and has since grown that to, in that time, to 6 lawyers with offices in both Surrey and Langley. Sarah and her team help workers, businesses, unions solve legal problems at work, from hiring to firing and everything in between, which would explain a lot of what's going on right now. Sarah's passion is to empower her clients and the public with practical legal information. She's been at the forefront of sharing employment law and information during the pandemic through media interviews, webinars, and reader-friendly blogs. Sarah's also been busy homeschooling her 3 kids and building a backyard chicken coop. The chicks arrive in June. That's great. Breaking news, Sarah was recently also nominated for the Canadian Lawyer Magazine 25 Most Influential Lawyers in the Changemaker category, and voting is open now. And I'm pretty sure if you check out Sarah on any of social media channels, you'll find the information there. And Jim's also joining us from Forte Law, Jim Wu, and he joined her about a year ago at the firm, also making some time before that to run his own employment law firm. Before law school, Jim worked as an EI adjudicator, which has probably been very helpful experience, as he says here, during the last few months, as we navigate EI and various other programs. Jim is joining us from his home in Burnaby today, and on weekends you can find Jim and his German Shepherd, I'm going to botch the name, Hachiko. Did I get it? I got it. Taking sheep herding lessons, so that'll be fun. That'll keep you busy for a while. So we'll go through that, and right now I'm going to turn it over to Sarah to kind of give you the disclaimer of we're not actually providing legal advice today. If you actually, we would highly recommend you seek a lawyer for anything you're going to do that's contract law and lease, and that includes any ideas that you get from the chamber. We suggest you consult a professional, but I'm going to turn that over to Sarah.
Yeah, sure. Thank you so much for having us, Colleen. It's, for those of you who weren't here when we were sort of chit-chatting at the start, it's so good to see Colleen and, you know, sort of virtually see some of the rest of you who I know I would see normally at Langley Chamber events. And we were talking about the Langley Animal Protection Society Gala, and kind of having some fond memories of times when we could all gather together. But here we are, and as Colleen pointed out, the commute for this kind of event is much shorter. So there we go, we saved some time. You know, as Colleen's talking about the new announcements that are coming out today, us lawyers get deep anxiety in the pit of our stomachs. And I'll be super upfront that I haven't even seen those yet. I've been in meetings all day and wasn't aware there was new WorkSafe information. Everything we have to say is hopefully still going to be valid, because it's covers some stuff that WorkSafe had on yesterday, which I would assume has maybe only been added to in more detail. And, you know, in particular with the schools opening, you know, those are all going to be very topical and interesting. So disclaimer is the legal world and the landscape is changing daily, hourly. This is very apparent today. And so we're doing our best to give good information, but, you know, all of it is subject to change, unfortunately, at this time, which is really unusual. I laugh with Jim and my other colleagues sometimes. We used to get really excited because we thought there was a change in employment law. Like when I look back from my 15 years of practice to date, it was like the things I thought were changes were like small, minor interpretations, not like fundamentally there's new laws being introduced. So it's an exciting time, but it's also, you know, a time when information we're giving in settings like this, you have to use your own good sense and certainly check to make sure it's up to date before you take action. We can't give legal advice in this forum. There is a chat function, I believe, and possibly Q&A. So feel free to put stuff in there. Hopefully we'll finish what we need to get through and be able to get to it by the time this wraps up. But we can't give you legal advice about specific situations. This isn't confidential. So be aware that anyone can see what you're posting. But if we can give you general advice that gets you pointed in the right direction, we're super happy to do that. And that's the goal today. So that's all I had for disclaimers. I must be a lawyer if we start with that, Colleen.
Sorry.
Okay.
Yeah, so what do your work days look like right now at Forte Law? How things must have been extremely busy for you moving forward.
Yeah, this is literally how every conversation starts. I don't know about you, Jim, but everyone I see is like, oh, you must be so busy right now. And we certainly are. I would say it was quiet in early April, which was a bit strange because we knew so many people needed our advice, but I think people were kind of waiting to see what was going to happen and what the programs were going to look like. But now we're very busy. This week for sure is, I would say a lot of businesses who are contacting us, thinking about reopening, but at the same time also thinking about maybe letting some people go permanently, like making some decisions about what their operations are going to look like in the sort of immediate term of the next few months, and trying to figure out how to do that. And it's not many businesses have sacks of cash sitting around right now that they can pay severance pay with. So it's a delicate exercise to try to navigate that. And of course, we also advise workers. So we're getting calls from workers as well who are, maybe on the receiving ends of letters and changes and trying to figure out what their rights are as well. So it keeps us really sharp doing both sides. Some people think that's a bit odd, but we see people getting letters similar to the ones we're giving advice on how to write them. And it obviously we would never do that for employees of our own clients. But it certainly gives you a good perspective on what's driving and motivating the other side. How about you, Jim? How are things? And I'm in the office today, which is exciting. And actually, Jim's at the office today too, which is the first time ever. So we're rebuilding.
Things are going well. It's funny how exactly the same thing people ask me, which is you must be very, very busy, and it's in a way it is. There's a lot of new things being explored out there, but I think sort of the same dynamics apply. Workers, they undergo situations at work, whether it's some of it because they haven't been paid, or it's because they're sort of in limbo about what to do with jobs. And same thing applies for employers. They are very concerned about whether they're in a position to be able to restore their workforce and what they need to get their businesses up and running again.
Yeah, and our goal today is to try to help you avoid conflict, because a conflict with an employee right now is so everybody, I feel like we're all in this like really vulnerable state where, one big lawsuit or even a small lawsuit, while you might have been able to weather that last year or in January, now that could be critical and to your company's business. How are things at the chamber, Colleen? You said you're working at home, is that right?
I'm going into the office a couple of days a week when I have a lot of calls and doing a lot of sessions like this. If I'm on calls all day, in order to allow my daughter to have some space in the apartment because it's quite small. So yes, so and the team's working from home right now. Everybody's working. Again, everybody says, "Oh, it must be hard with not doing events," but we've looked at everything from a different perspective, and so we're still moving forward. We're taking the organization forward. We've got policy session in BC Chamber AGM next week. So things haven't changed. We've just added this whole component that I like to now call the COVID file. That's kind of over here that we're working on constantly and every day. Meanwhile, we're still trying to keep the chamber on track and work with our networks, Canadian and provincial. I'm in more meetings now than ever. to make sure that our members' voices are heard to get these changes implemented. This morning, the Prime Minister announced that the wage subsidy would now be extended till the end of August, and that they're looking at opening up the parameters and changing the percentage that people can apply for. So it's really making a difference, and that voice going forward is what we've all been working on in the background.
Yeah, well, that's great. You guys are, I can imagine that is a ton of work, and I certainly see the information that's coming out, and I know it's appreciated. So let's jump in. Colleen, you want to pitch us question number 1? And I'll tell you right now, just for transparency, we were the ones that came up with these questions. And how we came up with them is they're literally the questions we're getting asked every day. So we figured those are the ones that are going to be most helpful for you. So question number 1.
Also, for clarity, some of the ones that were submitted pop right into these categories, and if not, I have those questions for the very end, and we can open up the chat to Q&A if we have time. So we will get to this. So one of the biggest concerns right now when bringing people back to work is ensuring a safe workplace. What can businesses do to comply with the health and safety obligations? And I think part of that, Jim, is going to be a lot of the stuff that was announced this morning was those detailed categories for each different, and I haven't been able to log in to see what they are because honestly, I get partway in and it starts to load and it crashes. So that, I'm going to say over to you on that one. It literally 11:15 was posted. So
awesome.
Sure. So there are the general rule is that every employer is required in British Columbia to guarantee the health and safety of their staff. In this case, it would not only be businesses guaranteeing the health and safety of their staff, but also potentially customers who enter into the business. So that primarily involves doing 2 things. Number 1, taking steps to ensure health and safety, and number 2, communicating to returning workers the steps you have taken to maximize their safety. Now at WorkSafe BC, this is the body that regulates our health and safety laws. They recommend having what they call a COVID-19 and returning to safe operation plan. So there are 6 requirements under that plan. Sarah, if we could get to the next slide.
Yep, there we go. I'm the slide operator, so any criticisms of that, come to me. There we go.
You'll see the 6 dots, wonderful. So the first of these is the risk assessment. So here's when you start asking some very deep questions about your business. These include where do people congregate? What jobs or tasks require your staff to come into close proximity with one another or with other customers? What materials are exchanged, including money, credit cards, paperwork, what tools, what machinery, and what equipment do your staff and your customers come into contact with when they enter your business? What surfaces are touched? Now be as liberal as you can. This can include things that you never thought of, and benign things such as doorknobs, elevator buttons, light switches, to any sort of, basically anything that can come into human contact with, those are now at issue. Step number 2 is to implement measures to reduce the risk. So WorkSafe BC has identified a few key areas which they recommend. The first being cleaning and hygiene. So of course, making sure that your staff has a safe area for them to wash their hands and to sanitize any equipment. Maintaining physical distance. So if it's, for example, if you happen to run a clinic and there's patients out there waiting outside, it might be a good idea for you to space out the chairs so that they're fairly spaced out in terms of their physical distance. You might want to also cooperate with the efforts of other stakeholders. So for example, if your business is inside a mall, maybe get in touch with the landlords of the mall to see what sort of steps they are taking to implement their physical distancing measures. Some businesses, physical distancing cannot be maintained. So in those situations, consider providing health and safety equipment to your workers. These can include giving them masks, gloves, and possibly installing plexiglass at certain places where basically physical distancing cannot be maintained. The third step involved is developing policies. Now, policies are very useful. They're useful because they help manage your workplace. And in here, you want to consider policies around who can be at the workplace, how to address illnesses that arises at the workplace, and how workers can be kept safe in adjusted working conditions. Now, WorkSafe has implemented this new rule where it's now mandatory for all businesses to have what's called a self-isolation policy. This requires all employees to go self-isolate at home for a requisite number of days if they are either of the following. Number one, if they are symptomatic. Number two, if they have arrived outside of Canada. Or number three, they have been in contact with a confirmed COVID-19 case. Now, as Sarah will be talking about this shortly, there is a requirement for the employer not only to make sure that these employees are self-isolating, but also to give them the leave and the number of days for them to actually go self-isolate, but also at the end of all that self-isolation, make sure that they have a job for them to return to. Number four, developing communication plans and training. This involves making sure everyone knows how to keep themselves safe while they are at work. Some things you can consider include putting out signages out in the entrance for customers for them to be alert to when they enter your business. Again, coordinating with other stakeholders, see what other businesses are doing. Do a test run and roll it out gradually. This is something that will require a lot of careful planning and thinking, and it would probably be a good idea to also complement it with what's being rolled out with our provincial government. Those I believe it was a total of 5 phases. Have your policies be adjusted to what's going on sort of at the government as well. The other thing I'm putting as a recommendation is make sure you have checklists prepared by your employees, because you will be asking them to do a number of things that they were probably never used to be doing. So it's making sure that they sort of implement this sort of as a habit regularly, so they remember to actually take these safety measures, and making sure that you give ongoing feedback to your staff and seek their input. And that leads to the 5th one, which is monitor your workplace and update plans as needed. So here, the key is to be susceptible to change and regularly seek input from your staff. Make sure you encourage workers to raise health and safety concerns. This is an obligation. Employers must do that. They must have a way for their workers to raise health and safety concerns at the workplace, and for the employer to also work together with the employee to resolve these concerns. And the last step is to assess and address risks from resuming operations. Some of you might be opening your businesses for the first time in a few months. So make sure that your workers they know what they're getting into. This can involve retraining some of them, maybe re-implementing orientation, refreshing staff on what they need to do to make sure that they're safe for work.
I think that last one, Jim, to me is really interesting, because I think we all get so focused on COVID and Lysol wipes and, you know, masks, and, you know, there's things we all jump to, but, you know, I think it's easy to forget that people are coming back. They might have, if they're working with equipment, they might be rusty on the safety protocols. And I think, you know, one thing we're going to talk about later in the session is a lot of people are coming back to jobs that are different, or maybe one person is having to do a bunch of different jobs, and it's equipment or locations they're not familiar with. And so looking at those safety hazards that would be there in any event, like regardless of COVID, but just might have arisen because you're reopening for the first time. So kind of getting the rust off. So I think that's a really good point. Go ahead, Jim. I
Yeah.
interrupted you. I'm famous for that. Sorry.
No worries. So these are all the steps again, summarized. And the last point we want to mention is also be prepared for an inspection. So if an inspection does arise, they will be asking you where is your plan to basically reduce exposure for your workers. And by making sure you take these 6 steps, you are miles ahead of someone who doesn't have that sort of a policy in place.
Yeah, so that's something we get a lot of questions about just from a practical perspective. Like people are saying, well, do we need to send this to WorkSafe? Like, do we need to get some kind of approval that we're safe to reopen? You know, unless that is in the news today, that absolutely wasn't the case. And I'd be shocked if they were reviewing everyone. So just like other workplace safety, it's the honor system. And so you need to have this in place. And it's something that you need, as a business owner, need to make sure is done. But you know, honor system means a lot of times things don't happen, right? I'm sure with reopening, everyone is very, very busy. So there's a couple of really good reasons I want to give you to do this, because whenever I start hearing about developing policies, I can see, Colleen's eyes weren't glazing over, I don't think, but if I could see the rest of you behind your screens, you probably were. Any business owner I talk to about policies is like, tunes out right away. So why do you need to actually do this? Well, I'm going to give you a couple of good reasons. So one is WorkSafe is still working. So like Colleen, they are doing their old jobs and more. They are still conducting inspections. The inspections are largely virtual, but you very much could get inspected, and that is something that is being predicted to be on the rise, is more inspections by WorkSafe. And you know, if you've ever been through a WorkSafe inspection, you will know that the more things you can give them right away that check off their box, the easier your life is going to be, and it's not going to suck up a bunch of your time and energy that you really need to be focused on rebuilding. The second reason is to deal with employee objections. So a lot of businesses we have will say, well, my workers are saying they don't feel safe, or they're not comfortable coming back to work. Developing a communication plan is part of this requirement from WorkSafe, but it's also going to be one of the key parts of actually getting people back. And to be able to deal with work refusals, if you get those people saying, it's not safe, I'm not coming back. Well, to have something objective that you can say, yes, this is safe, we went through the WorkSafe requirements, here's our policies, is something you can also share with employees to reassure them, and also potentially to sort of draw a firm line to say, no, we've done everything we need to do, and you need to come back to work if you need them here. So this was the link as of, you know, yesterday. If that has changed, it may have, but I would imagine the steps are probably the same. And we're literally recommending that you have a document where you go through these 6 steps and you've documented, assess the risk, what have we looked at? And there's more information on the WorkSafe website, which was some of the stuff Jim was going through about what ideas of things to think about under each of these. And then you should have that saved. If you have a joint health and safety committee, go through it with them. That's a process you should do with them. But make sure you have this for reference, so that if WorkSafe or any of your workers are questioning safety, you've got something to show, okay, you've done what you need to do.
I've been on several WorkSafe BC phone calls in the past week. The number one word of advice from all of them was, write a plan. It doesn't have to be a 40-page glossy document hand printed at the printers. It needs to be a 2 or 3 page, depending on the size of your business, a 2 or 3 page document that lays it all out, and you've gone through it. Because if they show up and you go, oh, well, let me show you what we've done, that's not going to work. If you don't have the document, they're going to be the first problem.
Well, and they're very likely not going to show up physically. They're going to get in touch with you and say, send me your plan. So you're going to need to have that to be able to offer up. And I think that I would imagine WorkSafe is going to be pretty hard on this. So that's all we have to say about WorkSafe. I'll be very interested to see what they have added to this today. I guess one thing I can say, I think Jim would agree with me, they've been really proactive in providing information. I think there's a lot of you know, we see a lot of criticisms of the phases and like the ambiguity of that. Well, you know, this is actually giving you a step-by-step framework to walk through. So I think that's really helpful. And I would certainly, what I always say is go to the horse's mouth on this stuff. So don't like hear through someone what you think you're supposed to do. Just go to the WorkSafe website. They have it, it's right all on the landing page. It's like, once that, I'm sure by, you know, if you want to spend your long weekend on WorkSafe's website, I'm sure the traffic will have died down from then now, and the links will be working. But that's the place to go to figure out what you need to go. Go right to WorkSafe.
Yeah, definitely. So
all right.
The BC government has also made some changes to the Employment Standards Act over the last little while around protected leaves. How does that apply to returning workers at this time with the reopening?
That's another very good question, Colleen. So this is something we're talking about a lot, and I find like this to me shows how long this has been going on. Because do you remember when it was like spring break and just before spring break and this was starting to come out? And I know if you're like me, you have school-age kids. Some of my neighbors and kids, friends, families had left a bit early for spring break, and so they were in Hawaii or Mexico when this all hit, and they had to scramble to figure out how to get home. That was around the time that this came out. It was one of the first things that the provincial government unfolded, was the protected leaves. So in my view, many of these leaves are coming up less frequently now because I think most people were able to get home. So people who are traveling and being quarantined, I think that's going to be less of an issue. But still could be. And of course, our case numbers, knock on wood, are looking good. And so I think people getting diagnosed, I'm hopeful that'll still be just kind of on the decline. But the key thing here is still remains school closures. So this is very much an issue now. I am in Surrey myself, school district parent, so I'm getting texts today from Surrey saying there's talk about voluntary reopening in June and what that might look like. And of course, that's all subject to the numbers staying good with COVID diagnoses. But for now, we're still in a situation where there's school closures and there's daycare closures. And so working parents many of them are not going to be able to come to work and may not even be able to work remotely depending on the circumstances. So if one of your workers has school-age children or minor children that they need to care for, they can say, I can't come back to work. I can't work. And you have to accept that as an employer as a valid leave, and you have to offer them their job back at the end. So you can't fire them because they say, I can't work because I have school-age children or minor children and the schools and daycares are closed. And that leads me to the second point. So this gets a bit tricky, and I think a lot of employers are going to have trouble with this. So listen carefully to this part. So that doesn't mean you shouldn't include those workers in your return to work plans. And I think that even more so now that we're starting to see some suggestion that things might be opening on a voluntary basis, don't assume what your workers are going to want to do. Even if the schools remain closed, don't assume what they're going to want to do. So what you need to do is include them in your back to work planning. So when you're sitting down thinking, okay, what work do I have? What workers do I have? Who do I need back when? Many companies are bringing people back slowly. So they're not bringing everybody back. They're bringing people back a few at a time. Some are bringing everyone back at a lesser level. Like there's lots of different ways to do that. But don't say, okay, well, I know Sarah's got kids at home, so I'm not going to bother her. I'll just call Jim because he doesn't have kids. So and that is a very natural reaction. And I think it's also a very human one. And it can be coming actually from a place of kindness and caring. But what that's doing is removing my right to say, hey, actually, my husband can take care of the kids, or I really need to get out of the house and go back to work. I'm going to do that the first day I can, or, my schools have opened, or whatever it is, right? So what you should be doing is including them in, offering them a return the same time. And then it's only if they say to you, I can't come back because I have kids at home that are not in school and the school's closed, then they have the right to say that. And then they're converting to being on a leave rather than on a temporary layoff, kind of conceptually. So it's kind of a funny point, and I get this pushback from businesses all the time, and I completely understand it. Like, on the one hand, you're telling me these people don't have to come back to work, but on the other hand, you're telling me I have to go through this kind of charade of asking them. And the answer is yes, you do. And it's because you're making assumptions about what they want and need. So you have to make them the offer, even if you know that that's going to be rejected, or you think you know it's going to be rejected. So that's a really important part. I think, given the announcements today about school closures, you know, I'm not sure what that's going to mean when it's voluntary. I would expect that the provincial government is hopefully going to give us some guidance on that, given that this is the law that says school closures mean you get a mandatory leave. I would expect, for the period of time that it's voluntary for parents to return children, it will probably extend. That's my gut feel based on information I got an hour ago, is that until kids can return full-time to schooling, full stop, there's going to be leaves. And from everything I've seen, even the return is going to be like days here and there. So yeah, so that's what I have to say about that, Colleen. Were there any questions? You're muted still. Any questions related to that from your feed, or that I didn't cover?
No, I think you covered off on that one thoroughly. And then actually it breaks right into the next question is when you talk about bringing back which person, who you're bringing back, what are the risks associated with bringing back certain workers and not others? I mean, in a union environment, it's very simple. It's cut and dried how it works. But in a smaller firm or a smaller office, or, you know, there isn't a seniority. How does that work?
Yeah, that's a great question. So, you know, the number one thing, like the hole that you want to avoid stepping in here, is human rights. And so this relates to the working parents, but also other groups. And one thing I've done here, and Jim made me this amazing slide, I would not be capable of it, is outlined all of the various prohibited grounds in the Human Rights Code. And what these are is, this is just law. So like, I get a lot of people that like maybe don't agree with some of them, but like that doesn't matter. That this is what the law says. So the law says you cannot discriminate or treat negatively any worker because of any of these things. So it's good to know what these are, and I find people are sometimes surprised. They don't know that there are this many, and you know, it's a larger list than they are used to seeing. But the key ones that are going to come up, I find, with returning to work after in the pandemic are age. So I get a lot of you know, people who are thinking, okay, well, I've got these older workers. We have heard that older people are more vulnerable, and we're in a situation now where people are working longer and longer into life. So you could have workers in their 70s or even older, and so that is a key one. Is so if you're saying, you know what, I don't think I'm gonna offer Susie because, you know, she's, you know, 78, and it again can be coming from a great place of like, I don't want her to get sick and I'm worried about her exposure. But if you're not making her that offer at the same time you're making it to everyone else, you're making that decision for her. Same with sex. You know, let's say you have a couple of workers who are about to go on maternity leave that are pregnant, and you're worried about their health, and you're also thinking, well, you know, they're going to come back and they're just going to go again. That's discrimination if you're not treating them in the same way that you're treating everyone else. Working parents is another, under family status, and of course disability too. You might know that someone has a chronic illness and you might think they're more vulnerable to becoming sick and dying, and so you don't want them, you're worried about asking them to come back, and so you're going to leave them and let them stay home. That's how you're thinking of it. But really, if you're not making them the offer, you're discriminating against them. And so this is really easy not to do. And so we've boiled it down to a do and don't. So don't let any of the protected grounds, which is listed on the slide before, influence your decisions on who to bring back or when. So do not do that. And what I recommend that employers do is once they've kind of got a plan, they think about it through that lens, just to make sure that something hasn't kind of subconsciously colored who they're asking or what directions they're going, and do instead choose based on skills, knowledge, and the work that needs to be performed. You can absolutely do that. You can pick based on who you need to do the work that you have. And there's nothing wrong with doing that. Aside, as Colleen said, in a unionized environment, that might look different.
Great. That the do's and don'ts are really clear. Clear is good. So there are also still many restrictions on how businesses can operate, and more of that came out today. That's where those details come into play per sector, including the physical distancing requirements and, of course, customer and worker safety. This could affect how workers' hours and their job duties. What should businesses keep in mind when adapting to new business operations?
So this is another question we're getting a lot, and the legal concept that applies is constructive dismissal. So if you are bringing folks back to work and their job is going to look different, either temporarily or permanently, it's going to look different in a significant, fundamental way. So for instance, like Jim works for me, he works full time. I say to Jim, okay, Jim has actually been at home working this whole time. So, but if he had been on layoff, I'm calling him back and I say, okay, Jim, I'm looking forward to having you back. I'm so excited. We're reopening. But I really only have work for you 1 day a week now instead of 5. That's a fundamental change to his job. And I find people are having a hard time getting their heads around that. But, I always say, just think about this before COVID. Like if you cut someone's job from 5 days a week to 1 day a week, that's really significant and fundamental. And I don't think anyone would have questioned that being a huge change. So what constructive dismissal is a fundamental unilateral changes to key terms of employment. It can be a reduction of hours or compensation. More than 20% is generally going to be a constructive dismissal. Or it can be a significant change to duties and responsibilities. So in some cases, you might be bringing someone back to do different jobs. Your whole business might have changed. So their old job might not exist and their new job might be, there's going to be a whole lot more delivery drivers in the world. I know that much. So that, those are the two areas of change. And people get really concerned about this, and I think it is an important thing to think about, but there's a really easy solution to it, and that's because of the word unilateral. So a fundamental change that is unilateral to key terms of employment. And what unilateral means is it's one-sided. So it's the business saying to the employee, this is your new job. These are your new hours. The way to get around that is to have the employee agree to the changes. So if an employee agrees to the changes, it's not a constructive dismissal. So what we are recommending you do if you are bringing people back to different work arrangements is start with a discussion with them. Might be phoning them up, maybe on Zoom and say, hey, look, this is what we're looking at. Here's what we're thinking. And then have them agree to the changes in writing. So you would send them something. It can be an email. It doesn't have to be a formal contract. It's definitely something a lawyer can help you write up. We've done a few of them, and the ones we do don't look like contracts. They look like a letter or an email. And then have the employee agree to that. So you have a record of them saying, yes, I accept those changes. Like I would write to Jim and say, just confirming our discussion about the change to work. We're going to be going down to 1 day a week. I hope I can increase it in future, but that's where we're at. Do you agree to that? So this is a really, we get a lot of questions about return to work agreements. Do we need return to work agreements? And we're recommending that you have them if you are going to have significant changes, either to the duties or to the compensation or hours of work. You're muted there, Colleen, still.
I pressed the button, but it didn't go.
I love it.
It's there is an easier way to do this, and you know, like you say, communication is key on all levels of this. Whenever we've talked to anybody about anything, communication is key. So there may be some workers that a business decides not to recall. What happens if they decide, like you choose to restructure, jobs, as you mentioned, are changing and get eliminated? What liabilities should be considered, especially with the changes to the Employment Standards Act recently, should before making this decision? What should people really look at?
I can cover that. So a lot of a lot of businesses are currently putting their employees on what's called temporary layoffs. So here's what you need to know. The key takeaway for temporary layoffs are they're temporary. So you cannot permanently put them off in a layoff situation forever. In fact, the most you can go is 16 weeks. What happens after even just one day after the 16-week is that you have what's called a permanent layoff. And the permanent layoff is exactly the same as terminating an employee. And what that triggers the business is that the business will then have to pay the employee termination pay or severance. Keep in mind that there's this term in employment standards, it's called a week of layoff. So a week of layoff constitutes, so remember how I said temporary layoffs, the most you can get is 16 weeks. Well, it's not just 16 weeks of absolutely no work. If you do not restore the work back to at least 50%, that is also considered a week of layoff as well. So in other words, if you recall some of your employees back to work thinking, okay, it's week 16, I'm going to call back all of them, but some of these workers are going to reduce their hours by more than 50%. Well, unfortunately for those workers who you just recalled back to work, those workers have actually been terminated because they've actually gone below the 50% threshold. Now, if termination does happen, there are sort of guidelines as to what you can expect in terms of liability. In Canada, we have this concept called severance, and severance is basically, every employee has it. What we look at first is their employment contract to see whether there's a specific number of amount of severance the employee is entitled to. At the bare minimum, that language must match local employment standards. And here in BC, we're looking at the maximum you can get is 8 weeks. The minimum is if you have an employee who's been there for working for less than 3 months, that employee is looking at 0 in terms of compensation. So that is what I call the mandatory minimum piece for severance. You must absolutely give that amount to the employee. The ramifications are if you do not give it to the employee can take this matter to employment standards, and the employer can actually be fined for not giving that amount of pay. Now, the other piece is on top of that, let's say if your employee does not have a contract or the contract doesn't really specify what amount of termination they can get, they can also get some additional payments through a wrongful dismissal lawsuit. And the amount there is based on 4 factors. It's based on the employee's age, the nature of their job, the length of their service, and the likelihood of that employee finding a job similar to the one they've just lost. In terms of what we can be looking at here, here in British Columbia, the courts have, the maximum for the courts is, there's a soft ceiling of 24 months. The 24 months, I say it's a soft ceiling because there are certain exceptional cases whereby if you have an employee who's been working for a very long period, let's say 4 decades at a certain business, and that employee is in their 70s or even in their 80s, that employee can actually probably get an amount that's even higher than 24 months. So there is potentially some liability for the business. Now, you'll see there's an asterisk saying subject to the duty to mitigate. So what does the duty to mitigate means? it means that the employee, whenever they're terminated, they have the obligation to be looking out for work. When they find work during their severance period, that would reduce the business's liability. So for example, if you have an employee, he or she's looking at 1 month of severance, finds a job 1 week into their severance period, then the employer's liability would probably be reduced only to that 1 week. So there are ways which you can potentially reduce the amount of liability should you have to go about terminating an employee. One of it is one of the things you can do is you can offer a reduced work schedule. You'll still probably be on the hook for termination pay. However, the amount of work you offer, it is a chance for the employee to say yes to a job. And if the employee does actually refuse, that can potentially reduce the amount of liability that the employer is looking at. So as you progress, as you reopen your businesses, keep in mind that there are these factors in play. And if the worst does happen, just be mindful that there are also additional steps you can take to minimize your potential exposure.
Yeah, the way I'm looking at it these days, Colleen, is like kind of like musical chairs. You can tell that I spend a lot of time at home right now. And let's say you have 20 people on your team and you start rebuilding. Well, maybe you're going to start by bringing back 4 chairs or 5 chairs, and over time you're going to grow. But you might only ever get up to 18 chairs, and there might be 2 people that are left without a seat. And if those 2 people are your most senior people who are the highest paid, you're going to have more liability than if those 2 people are maybe the most recent that you've brought on. So even though seniority doesn't apply, like you don't have to bring people back in the order you hired them, length of service is a big driver here. Like you can see on the employment standards and even on the common law notice, length of service is a really key piece. And so what I suggest is when I'm looking with employers and assessing rebuilding plans, I try to say, okay, who's going to be the most expensive to pay out if we don't have a spot for them at the end, and really thinking about that when you're deciding who to bring back and when to bring them back, because that's a key issue that can come up in this. Is severance pay, either because at the end of the day you don't have a job for everybody, or because they hit the end of that temporary layoff period. And that's been extended from 13 to 16. Maybe it'll get extended longer. Now that I'm seeing the wage subsidy out to August, it makes me think maybe it could go out farther, but there's certainly no guarantees of that. So right now, if you don't bring someone back within 16 weeks, you're going to owe them severance pay.
My political spidey sense on that one, and this is total hypothetical and crystal ball, is I don't think we will see much of an extension on that provincially. Labor unions have had a lot to say about that, and labor associations, and that being who we have as a sitting government right now, I don't know that we'll see that extend again. So yeah, that's.
Yeah, my theory was maybe they would kind of align it with the school closures. Like if schools were closed till September and restrictions are lasting longer, then I could see it getting pushed out. But yeah, I mean, who knows? We're all speculating.
Totally. Total speculation
and
on my
it's
part.
very hard to know. One piece on severance we didn't talk about in this slideshow, but is important to think about as well, is there is a section of the Employment Standards Act that says if it is impossible to continue the employment relationship, you can get out of paying severance pay. And the BC government has actually put in their policy and added to say that COVID can be this kind of unexpected thing that comes in and severs employment. In my view, that's going to be highly fact specific, and the government's actually said it'll be on a case-by-case basis. So the example I always use is cruise ships, right? Like when COVID started, if you owned a cruise ship, like you couldn't even dock anywhere, right? Like much less you have to fire everyone. Like you have no revenue. Who knows? Like I would imagine that'll be the very last to reopen if it ever does. So those people, I think, probably have a good argument to say that COVID made it impossible to continue their employment contracts. But for other types of businesses, it's going to be really fact specific. And I'm sure there's many other industries that were impacted in a similar, like extremely severe kind of overnight way, but there's others that maybe it's not quite as clear. So that's something to think about as well if you're in that situation of having to, for sure, like having to close permanently. Those would be the times.
Seeing a lot of issues, tourism operators that had to shut down immediately and are not looking at reopening within the timeframes. You know, they're not opening anytime soon.
Yeah, I would say you definitely want to investigate that. I mean, easy to say because these are the businesses that are the hardest hit and probably don't have money to pay lawyers. But, you know, any employment lawyer right now is super up on this stuff. We're advising on it every day, all day. So it's definitely worth, you know, a quick consultation to see if you can make sure you tie that up as well as you can.
I do have a couple of questions that came through from various people that were attending today. So let's cover off on those. We've got about 8 minutes. We'll see if we can buy into this. Can an employee refuse to go back to work and still apply for EI?
Oh, I'm going to leave that to my EI expert, Jim. Boy, when I hired him, I thought, oh, that's kind of interesting. He was an EI adjudicator. And the last 3 months, it's been like, oh, I have a golden nugget here. I just got so lucky.
Right. So the main question is, why is the employee refusing to go back to work? And I'll probably sort of as to give some examples, sort of one end and the other end. You have sort of on the extreme end, let's say if the worker is refusing to go back to work because he or she suspects that the workplace is just simply not safe for him or her to return to. Then what employment insurance will be looking at is, okay, well, what steps did you take to refuse the job offer? And in that case, if it's a situation where the employer has made every possible step, they took the 6 steps recommended by WorkSafe, they gathered the employee's input, and basically they've done everything objectively possible to make sure that the workplace is safe and sound. And in that case, the employee is still refusing to go back to work. I would say the employee's chances of getting EI are very limited, in the sense that if she applies, very likely she would have said to have quit her job. In that case, she probably would not receive EI because she did not demonstrate what's called just cause, and that's the test they're looking for. If an employee quits their job, they need to see what are the reasons. Did the employee exhaust all of her reasonable options? And in that case, the employee has the option to return to work. And because it was not exercised, that employee would not be entitled to EI. However, if it's the opposite end, let's say that the employee is in a situation where she cannot return to work because they have childcare obligations arising from the protected leave. In that case, the employee would probably have a reason. The likelihood of her getting EI would be much higher just because she's on a protected leave. He or she didn't look at all the available options and exhaust all of them. So again, the key question would be, what are the grounds for the refusal, and what steps did you take to address all of the other possibilities besides either refusing that job or quitting that job?
So I have a much less informed view on that, Colleen. I read in the National Post, this is my source, yesterday. I flipped this to Jim. We haven't had a chance to talk about it yet, but there was an article, someone has leaked an internal memo. Have you seen this? It's about CERB, not EI. And basically the internal memo is internal to the Service Canada, I guess. And it's saying just approve everyone, like just approve everyone. Everyone gets approved. And we'll worry about like adjudicating things later. So I think, you know, whether like EI and CERB, I would say our experience is the lines are very blurry between them right now. And a lot of people are just applying for EI, getting CERB. It seems like there's a lot of approvals happening. So, you know, this is consistent, news story is consistent with that. And I think so the answer might be, yeah, in the short term, you might keep your benefits, but in the longer term, you might have to pay them back.
Yeah, especially there's been some confusion. And of course, I think they said from the very beginning, if they're going to buck the system, they're going to get caught in the end. So
yeah.
Another question in here was, if a callback works, so for instance, if you called somebody back that you'd laid off because of COVID-19 and they decide not to return, can you just change the original record of employment, or do you have to issue another one?
So the question here is, did the employee experience what's called an interruption of earnings? Because that's the only thing that can actually allow an amendment to a record of employment to take place. So how an interruption of earnings would take place is, the simple question is, did that employee work at all during the layoff period? So even if they came in for just one shift, worked 1 hour and left, that will be enough for you to issue the new amended ROE, because that worker has worked. If the worker has not worked, basically was off the whole time on a layoff, then the answer is no. No further amendments would be required. But I say it with another caveat, which is, if you do issue vacation pay because employees did not originally leave it, that would be enough to trigger a new ROE being issued. So just be mindful of the rule that it's got to be 7 days without work and without pay. If one or the other is met, then you can issue the record of employment.
Great, thank you. And I think that's us for time today. I want to say thank you very much to everybody to attending. Sarah and Jim, thank you so much for the insight. I really, really appreciate it. I know that those that will be viewing later will be able to take some quick notes and get some information. And your contact information is up on the screen. So please, if you have further questions, contact Sarah and Jim at Forte Law, or any of our chamber members. If you click through on our website, I know people have been looking for business lawyers and other contacts. We have a full list on our website of people that can help you out if you have further questions. On behalf of the chamber, I'd like to thank everybody again for coming out today, and I wish everybody a happy long weekend. Take care. Thanks.
Have a great long weekend. Thanks, Colleen. Thanks, Jim.
Take care.
Bye.
Bye.